Support comes from St. Louis Public Library Foundation, helping the library serve children and their families with programs and services needed to become lifelong readers. More information about the foundation is at slpl.org.
This is St. Louis on the Air from St. Louis Public Radio. I'm Sarah Fensky. Can the government force sex offenders to put up signs telling trick-or-treaters to stay away, or does that violate their First Amendment rights? Could the state of Missouri block pills that cause abortions by claiming that the state has a political interest in keeping its teen pregnancy rate high? And what about the St. Lunatics lawsuit against Nelly? How is it possible that 3 of the 4 people suing the rap star say they never authorized the litigation? Today is our Legal Roundtable, and that means 3 top attorneys weighing in on these matters and many more involving our judicial system that spans the gamut from the First Amendment to a dispute among old high school friends. And joining us today to talk about all of this and more is Brenda Talent. She's a longtime attorney and was previously a partner at the firm now known as Bryan Cave Leighton Paisner. Today, she's the CEO of the Show Me Institute, which advocates for small government and market solutions for public policy in Missouri. Brenda, welcome back.
Thanks for having me, Sarah.
And we're also joined today by Eric Banks. He's a former city councilor and state prosecutor, and he's now an attorney and mediator at Banks Law. Eric, welcome.
Thank you.
And last but not least, we're joined by Sarah Swadesh. She's a labor and employment attorney who's in private practice at the law office of Sarah Swadesh. Sarah, welcome back.
Thank you.
All right, I want to dive right in. If you celebrate Halloween in Missouri, you've probably seen signs that are stating no candy or treats at this residence. Now, this wasn't because neighbors had become Scrooges. It was something that the state compelled sex offenders to put up in their yards. Well, you won't be seeing these signs this year. That's thanks to a lawsuit by a sex offender in Hazelwood named Thomas Sanderson and a ruling from U.S. District Judge John A. Ross. The judge says that the requirements to post the signs violated Thomas Sanderson's rights under the First and 14th Amendment. Sarah Swadesh, was this one a no-brainer?
It was a no-brainer.
It was. How did we have to have this law in the books then for so many years?
Well, I think the law only went on the books in about 2008 or 2009, and it was never enforced until recently, until the plaintiff took issue with it when he had the sign placed in his yard. But there have been multiple instances where the government has tried to compel speech in a similar manner. One of them arose out of Georgia in 2022. Again, sex offender had a no trick-or-treater sign placed in his yard. He disputed it. It went up to the federal court, went all the way up to the 11th Circuit, and the 11th Circuit said you cannot compel speech. You cannot put a billboard on someone's private property that they disagree with.
So Judge Ross is following the precedent that had been set in another state here. Brenda, do you think he got it right?
I think you got it right. And in fact, when you're talking about First Amendment issues, it really comes under close scrutiny. So really strict scrutiny. And if there are less restrictive means to accomplish the result that the state says that they have, of course, the state has to have a compelling interest, which is protecting kids. There is one here. They have to use the least restrictive means. And in fact, the law that is at issue has a number of different things that sex offenders need to do during Halloween. It's called the Halloween law. And those things in and of themselves are sufficient to protect the compelling interest of the state to protect children.
So one of these things, as I understand it, is that sex offenders have to keep their lights off, keep the door closed. They can't be standing out there saying, here's my bucket of candy. That part of the law, again, as I understand it, was not challenged by Thomas Sanderson.
That is correct.
Do you think there's any chance that a sex offender could challenge that and say, hey, I have the right to keep my house brightly lit and have this porch lit up? That's my First Amendment right to say something.
I wouldn't be surprised if we see another challenge along those lines. But I also think that there's an element of which, when you look at this law, because a number of states have enacted similar laws, that there might be a part of for individuals to say, I just don't want to put the light or shine a light on me. And the other part of all of this, though, is when you look at these various kinds of measures, we have a sexual registry, sex offender registry. So parents can check that out also if they're concerned about it.
Yeah, I mean, I have to say, as a parent of a couple young kids, I appreciate that we need to keep kids safe from sex offenders, but I can't think of any world in which my kids, while they're going trick-or-treating, that they would be put into harm's way, even if somebody had their door open. You don't go into the house. This feels like one where maybe it looked politically like a good thing. We need to protect the kids, but was it even protecting that many kids?
Well, I respectfully disagree with the decision rendered by Judge Ross. I am happy to resume my role as a contrarian in the group. I think that it was measured. I wouldn't have even known what the sign was for other than the person would just prefer not to be bothered on Halloween.
Yeah, because this sign wasn't outing someone as a sex offender. So you're saying you felt like this was fair. You think they could have, even on First Amendment grounds, there's a way it should have held up.
I do.
Well, so, Sarah.
I think it's a mythical menace, right? Sex offenders are not all the same. You can be an adult predator or a child predator, and you're not going to have necessarily adults out there trick-or-treating. It's not tailored towards children. So you can be on the sex offender list and not be a predator of children. I think it's overly broad. It's not narrowly tailored. I mean, I appreciate what they're wanting to do, but it is an infringement.
So Attorney General Andrew Bailey says he will appeal. Sarah, do you see any grounds if you were working for Andrew Bailey and he said, Sarah, come up with some way to appeal this thing?
Sure. I think on the Georgia case, what the judge said is there was no evidence of recidivism. So I would say to Mr. Bailey, I'd say, okay, show me which this predator he's violated before, and show me that he's a child predator, not an adult incident. I would say, we have to show that there's some present danger that we are preventing, not some mythical fear that it might happen. So we would need to know more about the actual offenders.
Mm-hmm. Brenda, so if we were able to show some specific harm, would that be enough to get over the First Amendment concerns here?
I don't think so, because the law is painted pretty broadly there. And, you even look at the language, and I actually thought there might be an argument here, well, the language, as you say, is sort of like, it's not saying sex offender here. It's just saying no candy or treats. But as you look at it and you look at the other cases, I think it's pretty clear that the judge got it right. He wrote a very well-reasoned decision. I mean, he walks you through it. And I find pretty compelling the fact that there are less restrictive means, and in fact the law already has those in place, to satisfy the state's compelling rights. I do think that oftentimes, though, you see, particularly when you're talking about state officials, that rather than making that judgment call of saying, it's not worth it, rather than assuming that risk, they go, we'll just appeal it. And then when we lose, it will say, well, the court made that decision. We didn't.
Right.
I'm defending the law.
How dare these judges? I'm doing my part. Eric, do you want to be the contrary voice here? Do you see any particular grounds that this could be appealed?
Oh, of course, yes. And I do agree with the reasoning of the other two panelists. I just disagree with the conclusions.
So Andrew Bailey, a lawsuit filed that he and counterparts in Kansas and Idaho filed raised some eyebrows in the last week. I want to say even Barbara Streisand tweeted about it. The world is watching Missouri. Now, this lawsuit is the attempt of several states to restrict the sale of mifepristone. That's a drug that induces abortions. It would bar the drug's use after 7 weeks of pregnancy instead of 10. And here's a really critical part. It would require 3 in-person doctor visits instead of none. That would make it something that Missouri people would not be able to use, basically. Now, they made this argument. This is what caught Barbara Streisand's attention. They made this novel argument that the state has an interest in stopping the sale of this drug because a lower teen pregnancy rate could lead to a loss of population, and that leads to a loss of representation in Congress. To a layman, this sounds bonkers. Haven't we spent years trying to discourage teen pregnancy?
Yeah, that's what I'm saying. I'm kind of like, I didn't think teens were supposed to get pregnant unless they're married.
I thought that was what society was trying to do. But does this serve a purpose legally? Brenda, is there a reason that the state would make this claim? Because let's face it, we know the state wants to stop abortion drugs, and this is maybe an effective road to get them there?
Sarah, the complaint that was filed by these attorney generals is 199 pages. This is one of many theories that they put in the amended complaint. And this, again, is, as a lawyer, I would say you can exercise some discretion about what you throw in there. But I do know a lot of attorneys, or in particular these state governments where they're just coming out with these lawsuits, are concerned about standing.
Yeah.
That does the court has jurisdiction? And the first case was dismissed on lack of jurisdiction because of who the plaintiffs were.
This was one where some anti-abortion doctors tried to sue over this exact same drug.
Right.
The Supreme Court said they can't do that.
So as a basis for standing, I would say, and if you go to the complaint, it's like one of the very last ones. It's sort of, this is a creative law student coming up with another theory like, oh, maybe this will provide standing if all these other reasons don't fall, if they all fall through. And the real standing argument is that we're a sovereign. We have a right to enforce our laws. The other harm is we incur Medicare or Medicaid expenses, so we can show a financial harm too. I mean, those are the kind of allegations which the state would be hanging the basis for standing on. Again, as I say, if I were one giving counsel, I might say, you know, you're sort of attracting attention where we don't need to attract attention.
Yeah, I mean, they do have some better arguments in here. There's a reason that I've led the show by talking about this particular one. Sarah, I imagine your jaw dropped when you saw this argument.
I mean, all of our jaws dropped. All of us were sort of speechless. But as a lawyer, I understand where they're coming from. In the prior case that Brenda mentioned, it was called FDA versus Alliance. And there was a group of anti-abortion doctors who sued to try to get the pill stopped from being circulated, mailed out. And the court said you didn't have standing. What standing really means is that you have been injured, that the other party caused the injury, and that coming to court can fix it. And the doctors in that case said, well, our injury is downstream consciousness, that we're being forced to do something we don't want to do. And the Supreme Court said, well, nobody's forcing you to give an abortion. Mm-hmm. So they struck that. And then the doctors said, well, the loss of our income, because these women are rushing into emergency rooms and we don't get to treat our other patients and we're losing income. And the Supreme Court said, no, that's too attenuated. It's too speculative that these mailed out abortion drugs are causing you to lose your income. And so what the Attorney General is doing here is he's trying to put a hook into anything that is causing a harm in Missouri. And he really has 4 arguments. 2 of them are okay. Mm-hmm. I mean, I think they'll pass a motion to dismiss. I don't know if they'd win on a summary judgment. But so one of them is that teen pregnancies increase our population, and by mailing out this drug, population declines. We lose money. We lose congressional representation. And my thought was, well, so does every state. Right. Like Texas is going to have a reduced population, and Oregon's going to have a reduced population. So I don't really think that's even though it's silly, I don't think it's going to go anywhere. Their next argument was, well, all of the emergency room services, so women can get the abortion drug in the mail. They take the drug, they have complications, they rush to the emergency room, and the state has to pick up the tab for it. Mm-hmm. But in the brief, somebody didn't do a lot of critical thinking, because they also admit in the complaint that women are going over to Illinois or Kansas or Virginia, and they're also getting the abortion there, whether it's chemical or surgical, and they're coming home to Missouri and they don't have follow-up treatment here. Mm-hmm. And so they're still going to the emergency room for follow-up care, and the state is having to pick that up as well. So whether it's being mailed to them in the state of Missouri or whether they're traveling out of the state is still picking up the tab. So I didn't really find that to be persuasive, because it's happening regardless. And I think Brenda hit the nail on the head. The best argument really is that it is our state. We have the right to regulate what happens in our state. Dobbs gave us that right to regulate abortion. We are trying to regulate abortion, and you are undermining us. I really think that's their best argument if they're going to go anywhere. Oh, and one of the other most silly arguments they had was girls in foster care. are wards of the state. And as the ward of the state, we get to decide whether they have the abortion. And maybe that's true, but that just... That just I struggle with that one. Even if it's true, I don't think that's a great argument.
Yeah, it's hard to see how politically that's palatable to a lot of people to hear that as the state's reason. But as you say, there are some other stronger reasons here. Eric, do you think the U.S. Supreme Court, which, let's face it, ultimately they will decide whether this gets its day in court, do you think they're going to be amenable to that as a way to get standing?
Well, possibly, but as an attorney in private practice, I'm all in favor of filing petitions in state court or complaints in federal court where I throw in everything but the kitchen sink. And I can see why an attorney would be tempted to do that to survive the standing argument. And he or she would gamble that no one's going to check on CaseNet to read the complaint or the petition, and nobody's going to check on Pacer. But as an elected official, I think that he or she is held to a higher standard, and that standard includes not making the state of Missouri the laughingstock in the nation and having Barbara Streisand tweeting about us.
I mean, Eric, you make a lot of good points there. Brenda did mention this is 199 pages. And certainly if I'm a private attorney like Eric filing this, I'm thinking nobody's going to read this lawsuit. Andrew Bailey should have known that people were going to pour over this. This is such a charged issue, and 3 different states filing it. Is there an advantage that comes with throwing as many arguments as you can? Let's take the political considerations off the table. Sarah, when you're litigating a case, do you take the route that Eric takes where you're like, you know what, this is one of my weaker arguments. It doesn't hurt to throw it in there?
I don't.
You don't? Okay.
I don't, because when I bring a lawsuit, I want the judge, I want opposing counsel to know that I'm serious. I want them to know that I've vetted it out. I want them to know that I'm bringing something legitimate, and we're not going to deal with BS motions to dismiss. We're going to move forward. I understand the urge to throw in everything but the kitchen sink because lawyers are constantly terrified of malpractice. Oh, if I didn't make the argument, the client will be mad. Oh, if I didn't make the argument, I missed something and my client lost out. I mean, the urge is there, but I say resist the urge.
Brenda, I'm curious how you fall in this divide.
I vote, well, obviously, as an attorney, you shouldn't present any frivolous argument. That's a no starter. But my theory had always been you need to figure out whether what you're arguing undermines your basic arguments. Mm-hmm. So there can be arguments that you say are tangential or in the alternative, which don't hurt your credibility and the strength of your case, which you would say, probably not, but it doesn't hurt. And so then I would. But I'm with Sarah on this. I mean, I think as a counselor, you're supposed to exercise that judgment in your client's best interest. You should inform them. But, really, when you look at a 199-page complaint, I do think of a law school exam where you get points for issue spotting. Mm-hmm. And whoever wrote this did a great job of issue spotting. Would get maximum points on the law exam, not necessarily something as a practicing lawyer you want to file.
For those of you listening out there, I'm curious what you think about this. You can give us a call at 314-382-8255. That's 382-TALK. Maybe you have a question for our panel. If we can answer it, we'll try to do so. You can also send us a tweet at STL On Air. And we're talking, of course, to our Legal Roundtable. That's Brenda Talent, Sarah Swadesh, and Eric Banks. We need to take a quick break. We'll be back shortly. This is St. Louis on the Air on St. Louis Public Radio.
The Gateway brings you the day's news each weekday from around the St. Louis region and the state capitals in Jefferson City.
Our schools are accredited. We don't need this bill.
And Springfield.
How many more years must pass before lawmakers see time is of the essence?
I'm Abby Larico. Join me each weekday for The Gateway on the STLPR app or wherever you get podcasts.
Welcome back. I'm Sarah Fensky. I'm here today for our monthly Legal Roundtable. You can always catch us towards the end of the month as we chew on what has happened over the course of the month, all the interesting legal issues that have cropped up. I always learn so much from talking to the smart attorneys who lend their time, share their expertise. And today that includes Eric Banks. He's a former city councilor and state prosecutor. He's now an attorney and mediator at Banks Law. We're also joined today by Sarah Swadish, a labor and employment attorney. She's in private practice at the law office of Sarah Swadish. And also Brenda Talent, a longtime attorney, previously a partner at the firm now known as Bryan Cave, Leeton Paisner. She is CEO of the Show Me Institute. They advocate for small government and market solutions in Missouri. Now, a high-profile case involving state lawmakers ended with a whimper this month. It might not be totally over, but it's not looking so good right now. There were headlines when state lawmakers wrongly accused a Kansas man who was photographed being handcuffed at the Kansas City Chiefs parade. They accused him of being the suspect in a mass shooting there. They also accused him of being in this country illegally. Well, it turns out neither was true. He just had a little bit too much to drink. It could happen to any of us. So the man sued the lawmakers for defamation. And just in this past month, a federal judge kicked out the case. He said that Republican state senators Rick Bratton, Denny Hoskins, and Nick Schroer had not shown they intended to target Kansas with their posts, and therefore they shouldn't be sued in a Kansas court. I have to say, this is one of the most confusing parts of the law, Brenda, trying to figure out what jurisdiction people are supposed to be in. Is it equally confusing for practicing attorneys?
It can be. It can be. In this case, I mean, the issue is whether the court had personal jurisdiction over these legislators who are located in Missouri. They're not in Kansas. The lawsuit was filed in Kansas. But there is this concept when you're talking about tortious conduct that whether you purposefully directed your activities towards a state, those types of activities might give the state jurisdiction over you. Now, when you're dealing with social media, and I'm relying upon the court because I do not profess to be an expert in this area,
Sure.
The court said that when you're dealing with these kind of social media torts, if you will, that you have to have an intentional action that was expressly aimed at the forum state, which would be Kansas, with knowledge that really the impact of the injury you would cause would be felt in the forum state, in Kansas. And there's no evidence that what these legislators did was in any way directed towards the state of Kansas, was meant to have an impact in Kansas. You can argue what their impact was in Missouri because the actual activity happened in Kansas City, Missouri, and their Missouri legislators. And that's why the court ended up dismissing the case for lack of jurisdiction.
And it's not enough that the victim lives in Kansas? I mean, isn't he targeted and he's a Kansan? That's where a layman might get confused.
No, not when you're dealing with something like social media. At least that's my understanding. Now, if those individuals had come into Kansas and physically hurt him, then there would be a different issue because they would have been present in that state. But that wasn't the case. And actually, one of my questions is, why didn't he just file in a Missouri court?
I'm so glad. I want to turn over my microphone to you because that was going to be my follow-up question. Eric, is there a strategic reason why this guy would say, okay, I'm going to file this in Kansas. Maybe I can get a leg up by filing in Kansas?
For the life of me, I can't understand it. I mean, the filing fee in federal court is $400, whether you file it in Topeka, Wichita, or whether you file it in Kansas City, Missouri, or Kansas City, Kansas. So I don't see any justification for filing it in Kansas.
And Sarah, do you think it should have been clear-cut if somebody was thinking through these issues, that it's like, yeah, I should do this in Missouri because these are Missouri lawmakers? Like, that makes this easier.
Yeah, the lawsuit should have been brought in Missouri. The Kansas judge got it right. And you said it ended with a whimper. I don't think it did. I mean, the plaintiff's lawyer made a calculated decision to keep the case in Kansas. Missouri is a circus. I don't want to join the circus. I want to pull a few of the circus performers out of the circus. I want to go to Kansas where it might be a little bit smoother, a little bit calmer, less charged. I think I would have filed in Kansas anyway.
You would have? Okay.
And I would have said to my client, they'll probably transfer us to Missouri, but let's take a chance on coming over to Kansas. And the Kansas judge said, I'm not going to transfer you. You're not running low on time. I know what you did. Go refile over in Missouri. So the Kansas judge didn't tolerate the venue shopping and dismissed their case. But I don't think it ended with the whimper because there wasn't a dismissal on the merits.
Sure.
The Kansas judge didn't say there's nothing here. He just said, wrong courthouse.
They can refile in Missouri. They can start this thing all over. It's not like there's some penalty they're coming in with. The main thing is they'll just have to pay that filing fee that Eric referred to.
Yeah, and that's, so what, $400.
But don't you think also, Sarah, that perhaps in this decision that was issued by the Kansas court, that he drew a distinction among the legislators and what they posted, and at least one of them, and I always butcher his last name, Nick Schroer. His, if you read the opinion, it suggests that he didn't really say anything that was too defamatory.
Yeah, he may be able to get this quickly dismissed if it gets refiled in Missouri, but the others may have more trouble.
He drew a distinction among the comments that they posted on social media.
Do you think that will change then? You know, this guy says he's going to refile. He goes to Missouri and refiles. Would you leave off the weakest case? I guess we know where you stand, Eric. You're a throw everything at the wall kind of lawyer.
Well, not all the time. But I think that the lawsuit is fruitless, worthless, and without merit wherever it's filed. So I think that the legislatures are protected by the functional equivalent to legislative immunity. It may not be called that, but if we're going to start successfully suing plaintiffs, suing elected officials for things that they say, the courts will really be overburdened.
Sarah?
Oh, wow, I wildly disagree with Eric. Richard Jewell. He was the 1996 Summer Olympics bomber who was not the bomber. He sued NBC. He sued all the media outlets, and they said, First Amendment, we have the right to, broadcast news. And he said, you do, but you got it wrong, and you need to be careful. These legislatures were not saying, we need to fix our immigration laws, and we have concerns about people coming in from foreign countries and shooting. They said, that guy, he's illegal, and he's the shooter. There was nothing legislative happening in those defamatory comments. I would take this case.
It's interesting. Andrew Bailey is making the argument that Eric was making there. He's saying that they were directing these comments at the president, that this was about immigration policy. They're saying, here's what undocumented immigrants are doing to America. Brenda, do you think that argument could carry any weight with a judge, that they'd say, okay, you're not writing it in a letter to the president, but as you're putting it out there on social media, you're getting your point across on an issue that you are admittedly passionate about?
Well, you can make that argument, but there were some comments there that had I been their assistant, I would say, you need to think twice about this, because you don't have to label this individual when you don't have all the facts. You know it's developing. You could avoid it all by saying, rumor has it that an illegal immigrant was, and then you could get your point across the same way without targeting an individual.
Yeah. I mean, I think you make a good point. It's dangerous when you see people on social media who are just plucking, private citizens and accusing them of heinous things. I think the Richard Jewell case, it's amazing how even when you say his name today, immediately what flashes into my head is, oh, that was the Atlanta bomber. And as you pointed out, that was not the Atlanta bomber. But that's always going to be linked to his name. This one was corrected a little more quickly. I have to wonder if that can also maybe help these lawmakers. I think these tweets were up for about 24 hours.
No, this plaintiff, Mr. Loudermill, he was receiving death threats. Mm-hmm. No, that is unacceptable. It's only up for 24 hours. Well, too bad. It's still defamation.
Eric, I'm going to give you the last word on this one. I mean, you make this argument, legislative immunity. We do need to have our lawmakers have some freedom to comment on things.
And I am shocked to be taking a position that Andrew Bailey is also taking. So
you truly are the contrarian today.
That's right.
Yes. All right, let's talk about a different case. This involves the Simon Law Firm based in St. Louis. They have had some huge verdicts lately. I feel like every time I'm seeing their name, it's something that's more than $100 million coming out of a jury. I don't know what kind of magic sauce they have. They recently won $535 million in an Illinois case. A 13-year-old girl was raped at a psychiatric facility in Champaign. The facts were extremely disturbing. There was a 16-year-old male patient placed in a room right next to the girls. Surveillance footage showed that the boy and an accomplice had covered the cameras in the unit with toothpaste 75 minutes before this sexual assault. No one cleaned the cameras. No one intervened. You can see why the jury would be angry about this. It led to $475 million in punitive damages. That's some pretty pretty big compensatory damages there, too. Now, Judge Jason Bohm lowered that all the way down to $120 million. So in some regards, Eric, these feel kind of like just numbers on a piece of paper. $475 million, $120 million. Who can pay either sum? Why lower it?
Well, I think that it shocks the conscience of the public a lot less by lowering it. Now, whether or not it's lowered enough, that's anybody's guess. I still think that the verdict is very high, and it's gotten the defendant's attention, or it should.
Which is the point of these punitive cases. Sarah, what do you make of this number that they came in with and then the number that the judge knocked it down to?
I don't think it's too high. The institution advertised as being very safe, and it clearly was not very safe. They didn't even clean off the toothpaste after an hour and a half. So the girl was awarded $60 million compensatory, and compensatory generally means like sadness, depression, humiliation. So she got $60 million for that, and then they also received $475 million in punitive, and punitive means punishment. It's not because the girl was upset, but because the jury wants to send a message and punish the company. You can't put the company in jail, so you hit their pocketbook. The judge reduced it to, I think, $180 million total. The girl kept the $60 million in compensatory, and she got $120 million in punitive. And what really caught me is the plaintiff's attorney afterwards said the court's ruling still sends the strong message about accountability to companies. And I thought, well, that doesn't sound like an appeal. That does not. That sounds like they're going to take the money. And I thought, well, you just gave up $400 million.
Do you think they gave up $400 million because they knew otherwise the appellate court would knock it down even farther?
I mean, I don't gamble with $400 million for my client, so I would probably take the deal as well. But punitive damages at 10 times the amount couldn't get struck. We're not at 10 times the amount. 10 times the amount would have been $600 million, and she got $475 million. So it is certainly high, but I didn't think it, quote, shocked the conscience. I don't think it was unconstitutional. And my thought was, maybe there's a high-low agreement, and that is when the parties come together, the plaintiff comes and the defendant come together, and they say, we will settle in this range. Whatever number the judge gives, if it's in this range, we stick and nobody appeals, meaning the plaintiff says, okay, I won't take more than $400 million, but if the judge comes back at $500 million, I don't get it. I only get the $400 million, but there's also a bottom number, like a floor. So if the judge comes back at $100 million, the floor maybe is $200 million. So no matter what happens, the plaintiff gets between $200 and $400 million.
Lawyers are making these kind of deals
Frequently.
Wow.
Now, my son accuses me of having a Better Call Saul law practice. I prefer the term meat and potatoes law practice myself. But all of these numbers are outside of my realm of reason, and I have never heard of a high-low agreement that's $40 million on one hand or to $160 million. Because I don't live in that type of reality. I don't deal with those types of numbers.
Are there a high-low where it might be $100,000 to $300,000?
I've seen that.
Okay, so lawyers are making these kind of agreements, and that's just to sort of limit, okay, we don't want to be fighting this in the trenches of appeals courts for years on end. We're going to agree that we agree this might be reasonable to be within this range?
Yeah.
And bottom line, often insurance companies are involved in this, obviously.
They
The
help
liability.
decide the high and the low?
Right. The other thing about this case, though, was that the judge, when he reduced the award, he said he didn't find maliciousness. I mean, that was it. And so that kind of finding can also make you sort of come to the table. But the other thing, and I'll just ask my other two panelists this, my understanding is that if a judge believes that part of your compensatory award really includes other things to punish the party, that typically it's not unusual when you see that kind of large compensatory award to say that the punitives is only like 2 times the amount of that particular, as compared to if you get nominal damages where you can see a really high multiple on the punitive because you need to send the message.
Do you think maybe these compensatory damages are a little high? They reflect maybe the anger that the jury's feeling at this plaintiff.
I think it's definitely possible.
Sarah, thoughts on that?
The jury heard the evidence. They saw the testimony. I'm not a fan of the judge taking it out of the jury's hand. We don't know what testimony. Maybe the girl is suicidal. Maybe she has lots of trauma. Maybe she needs lots of therapy. We don't know what the jury heard. If the jury believed that she had $60 million in compensatory damages, then she had $60 million in compensatory damages. I don't believe. I trust our juries. They are smart. They know the difference between compensatory and punitive, and they gave her $60 million in compensatory, and they gave her $475 in punitive.
But didn't the judge sit there and hear all the same testimony?
He did, and he said there was no actual malice. He didn't believe that the company wanted the girl to be raped.
Sure. Well, one should hope.
Right, and I say, so what? There's also wanton indifference. There's high disregard of negligence, and that can be the same thing. So the jury heard it. I wouldn't have touched the verdict.
Boy, you get an awful lot of counseling for $60 million even today with inflation.
Yeah, that's a compensatory number that's pretty good there. Eric, I feel like I see these judges doing this a fair amount. Juries will come in with some really high numbers, and the judge is going, hey, I'm going to throttle this down before anyone can even take that next step of trying to appeal this. Do you feel like that's a good way of some of these nuclear verdicts that maybe where a jury is getting very wound up, that helps it then stand up on appeal?
Yes, but also the reasoning seems to be that the appeal is going to be on behalf of the plaintiffs. The defendants have just as much right to appeal this as the plaintiffs do. So the defense will probably still appeal it to get it down, even to attempt to get it even lower than what the judge reduced it to.
Sarah?
I have to respond to Eric's flippant remark about $60 million getting a lot of therapy. We don't know what testimony that girl provided. Maybe she's suicidal. Maybe she doesn't trust anybody. And maybe she will never have an intimate relationship with another partner again. That sure hell deserves $60 million.
That is Sarah Swadish. We're talking today to our Legal Roundtable, which also includes Eric Banks and Brenda Talent. We do need to take a quick break, but when we return here, we're going to talk about the latest in the lawsuit against Nelly. He's being sued by his high school friends and former bandmates, but maybe only one of them. This is St. Louis on the Air on St. Louis Public Radio.
If you have a smart speaker, you have access to the entire world of NPR and St. Louis Public Radio. All the latest news and all the captivating stories. Activate our voices with yours by telling your smart speaker to play St. Louis Public Radio.
Welcome back. I'm Sarah Fensky. I'm here with our Legal Roundtable, having some heated discussions today. It's great to see people agreeing to disagree on some important matters, doing it with civility. That's what we're all about here at St. Louis Public Radio. I'm joined today by Eric Banks, who's now an attorney and mediator at Banks Law. Also, Sarah Swadish, who's a labor and employment attorney at the law office of Sarah Swadish. And Brenda Talent, who's a longtime attorney. Also today, the CEO of the Show Me Institute, which advocates for small government, market solutions, and deals with public policy here in Missouri. So this isn't quite a matter of public policy. We may be taking Brenda just a little bit out of her wheelhouse, but we got to talk about Nelly. This is a case that I've just been so fascinated by. He was best friends in high school with these guys, the St. Lunatics, and then they filed a lawsuit against him. Well, that lawsuit has hit a pretty big snag. Several members of the group whose names were on this original lawsuit, they say they want nothing to do with it. Now, originally, this lawsuit said that 4 of Nelly's 5 bandmates hadn't received proper credit or payments for their contributions to his 24-year-old album, Country Grammar. And now 3 of these guys say they've actually hired Nelly's lawyer, Scott Rosenblum. He's now representing them, and they never authorized this lawsuit. So there's one remaining St. Lunatic, this is Ali, trying to continue this case going forward. Eric, is this a big problem for this litigation that instead of 4 people saying, hey, we were all in this together and we were lied to, there's now one guy and he's against 4 guys?
Well, it's a bad optic. I don't see how the attorney made the mistake. Lesson learned going forward, I will make sure that I would not take any lead plaintiff's word that these other 3 people have authorized me to speak to them for them. I guess that seems common sense with me in hindsight, but I would drill down and do a better due diligence before I put somebody's name on the pleadings.
Yeah, I mean, could you, as a lawyer, file a lawsuit on behalf of me and my 2 sisters without necessarily talking to my 2 sisters? You're kind of taking my word for it that my sisters are dying to pursue this litigation?
I don't see how.
Yeah. Brenda?
I would say no. Unequivocally, no. And there's no for a number of reasons. One, of course, is as a lawyer, I've got to be sure that the client wants me to represent them. But aside from them, when you're talking about multiple plaintiffs, they could have adverse interests. And there are forms that we would always have people sign to make it clear as a lawyer who I'm representing, that there's a waiver, or that if I'm representing a group, I'm going to represent the group. And if there suddenly becomes some adverse interest, you're going to have to get your own lawyer. I might have to step out of it. I mean, there's a whole bar procedure of what you need to do when you're dealing with multiple clients who you're representing, where there's a possibility of And when you're talking about copyright, there, to my mind, there's a number of areas that could come up where they would be adverse to one another or potentially have a conflict. And then I'll just make the joke. I mean, because this lawyer apparently is from Atlanta, Georgia. Fulton County needs to get in charge of their county bar and make sure everyone understands the ethical rules there.
Whoa. Well, I hope they're listening to the show today and take this call to action very seriously. It's interesting that you raised that. It sounds like a good lawyer in this case would have had a very serious conversation, sitting down with all of these people, not just getting them to sign off on a paper, but to say, hey, do you understand if this goes south, I'm the primary lawyer for City Spud. That's one of the members of the St. Lunatics. You are not my primary client here. Without that happening, this could be how we get into this jam.
And assuming that Atlanta attorney is not licensed in Missouri, I also think that the lawyer who filed the motion pro hac vici to get him admitted to practice on this one case has some exposure as well.
Oh, interesting. So if you're a lawyer in Missouri who's like, I'm going to get this person in to have the ability to do this, that could be a problem.
Yeah, especially when it goes south like this one has.
So we spoke previously on this show about a lawsuit Andrew Bailey filed over abortion pills. He's also been in the news for his efforts to fight an apparent wrongful conviction. The appellate court handed down a unanimous opinion vacating the conviction of Sandra Hemme. She spent 43 years in prison. Now, the trial court judge said earlier this year she was a victim of a manifest injustice. Bailey sought to appeal that. The appeals court didn't just rule against him. Our sister station, KCUR, says their 71-page ruling was handed down remarkably fast. This was just 13 days after oral arguments. It rejected every argument made by Missouri Attorney General Andrew Bailey. Sarah, does speed matter? Should we read something into this that they're just wholesale rejecting everything that he tried to raise?
That would be the short, accurate answer. Yeah. So at the hearing, Hemme produced an FBI report that essentially said she didn't do it, somebody else did. And Hemme's lawyers 40 years ago was never given that report, but they got their hands on the report in the last year. They presented it at the hearing, and Bailey's argument was, hey, we didn't get that. You didn't tell us you had it. And the Court of Appeals said, oh, my God, you had it 40 years ago. You were supposed to give it to Hemme, and you didn't. So take that elsewhere. We don't want to hear it. And I think a lot of the arguments went that way for Bailey. But what I picked up on and was appalled by is Christopher Dunn was ordered to be released from prison, and Bailey called the ward and said, don't do it. And Sangheiser said, get him out, get Dunn out now, or you are in contempt of court.
This was another wrongful conviction case in St. Louis County.
That is correct. And Hemme, same thing happened. Court of Appeals said, release her, and Bailey called the warden and said, don't release her. And the judge in the Hemme case said, if you don't release her, you, Bailey, will be held in contempt of court. And Bailey said, okay, let her go. So he's willing to risk his attorneys, but not himself. And he's done it twice. And I think he should be held in contempt.
Do you think he'll try this a third time? I mean, it sounds like judges have put him on notice. You are not supposed to call the warden.
He is our attorney general. If anyone is supposed to be complying with the law, it is him. He should have his license suspended for a week, a month, something, held in contempt. If the attorney general doesn't have to follow the law, why does anyone else?
Eric, it was described as a scathing 71-page ruling. You've defended Andrew Bailey a couple times on the show. Anything that you'd want to defend him on with this one?
Oh, well, when it comes to Andrew Bailey, my daddy said if you can't say something good about somebody, don't say anything at all. The man wears nice suits.
Oh, well, there you go. You found a good one there. I think a lot of the people fighting these innocence claims have become very frustrated with just how adversarial he has been in this process. But it has been interesting to see this play out. You know, the state has had a wrongful conviction law for about 3 years now. There were a lot of things that weren't clear about who was supposed to be in what role. Brenda, I feel like it's kind of coming into focus, even if it's not exactly what people had envisioned, and even if maybe the judge is saying, hey, Andrew, you don't have the right to do this. We are understanding more about the function of his office here.
It's right. I mean, look, when someone's been convicted by a jury and you believe the process, you've got to defend the process. I mean, so from that perspective, I can say that's his role. He's defending the process that occurred. But at the same time, when you find out, again, as an attorney, that there have been deficiencies in the process, you actually have discretion to make the decision about whether you're going to continue in that role. And as I mentioned earlier in the program, a lot of government attorneys think, well, the safest course of action is just to be out there and keep saying no, 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 and let the court say yes, yes, yes. Then I'm not the one making that judgment call. And I would say, you know what, as an attorney, you need to have a little more confidence in your judgment, and you need to be able to defend your judgment and exercise it in cases like this. And we've seen multiple ones that you provided us with where it was the kind of thing is like, you know what? You either need to be in control of your office and how people are behaving so they comply with the law, or you need to exercise the discretion that the law gives you to say, we're not going to waste taxpayer money in pursuing these kind of arguments.
Mm-hmm. Well, hard to argue with anything that Brenda just said. I'm going to move on to one last case, and this involves an Illinois restaurant facing a flurry of lawsuits over food poisoning. People say they got sick after eating at a Longhorn Steakhouse in Fairview Heights, Illinois. 3 lawsuits have been filed already, but a local lawyer says he's been retained by 80 people. Sarah, is this as bad as it sounds for this restaurant?
It ain't good. It ain't good. It's not good publicity. I hope they have insurance. I mean, the food poison they got is called Shigella. I think maybe that's how you pronounce it.
I think you're saying it right.
Yeah, what that really is, it's food poisoning from fecal matter. So it's not like the restaurant got a bad batch of beans and served 80 people. It's not like they had, punctured milk jugs and didn't know that the food was bad. There's a cleanliness problem at that restaurant, and they're gonna pay for it.
Boy, I'm glad we're talking about this during the lunch hour. I'm sure all of you are too. But I think Sarah makes a great point. You know, we've all seen this McDonald's case that has been in the news. It sounds like it wasn't them. It was a supplier. Like there's something wrong with the onions. You're saying this is different. Is that going to hurt them in a court of law?
It shouldn't be in court.
You think the restaurant just needs to settle this as quickly as they can?
Their insurance company. It's a franchise. Big Daddy Longhorn needs to step in and save its image and deal properly with these individuals who got sick.
So, Eric, a lawyer for these restaurant patrons said his goals were to get people compensation for their medical bills, lost wages, and, quote, the horrible, horrible experiences that they've had. This sounds like maybe compensatory damages.
Yes, I agree.
Do you think $60 million?
No, I don't.
I mean, we have 80 people, Eric, suffering severe gastrointestinal distress.
Yeah, but I think that it's going to be hard to put a dollar figure on how much those 80 people have suffered. Did they go to the emergency room? Did they have any prescriptions given? Did they have any follow-up treatments? And that's going to probably, for most people, be less than $2,000. So I don't see this as being an astronomically large lawsuit to get settled. I think the publicity is going to be harder for them to overcome than the lawsuits are. And I know for a fact I will not be eating at that Longhorn.
Fair. Is there any chance we could see a class action lawsuit coming out of this? We all were sickened. We have similar circumstances.
You could. If it's really 80 individuals who got sick, you could. But I agree. This isn't a $60 million case because, I'd take a bout in the bathroom for $60 million. It's just not going to happen. That's not where it is. So there could be a class, but it's not going to be a $60 million class unless somebody died. I mean, it can kill you, but we haven't heard that anyone has died other than unpleasant experiences.
Brenda, I'm going to give you the last word on this one. Anything that strikes you as a lawyer looking at this unfortunate case of food poisoning?
If I were counsel to the restaurant, I would say be sympathetic, reach out to everyone, show that you care so you can mitigate what you're going to have to pay out in the end.
Well, Brenda Talent, CEO of the Show Me Institute, I want to thank you for joining us this month.
Thank you for having me.
And Eric Banks of Banks Law, thank you for being here and being our resident contrarian on this roundtable.
Thank you. It was certainly lively.
And Sarah Swadish of the Law Office of Sarah Swadish, always a pleasure to have you.
Thanks.
This episode was produced by Sarah Fensky.
Our audio engineer is Aaron Dorr. This podcast was mixed and edited by Aaron.
Our executive producer is Alex Hoyer.
St. Louis on the Air is a production of St. Louis Public Radio. Understanding starts here.
Do you find yourself regularly listening to episodes of St. Louis on the Air? Suggest us to a friend you think might enjoy our conversations. And leave us a review and rating on Apple Podcasts on the App Store. It's the simplest way to help people discover our show. Thanks.
St. Louis Public Radio is a member-supported service of the University of Missouri St. Louis.